Hello friends, in the series on the income tax cases, today we will discuss a case in which the issue before Kolkata ITAT bench was that if the additional commissioner gives his approval by writing that yes, I am satisfied and the notice may be issued to the assessee, so whether this approval is as per the mandate of section 148 and section 151. This issue has been taken up by Kolkata ITAT bench in the case of Rungta Irrigation Ltd versus Assistant Commissioner of Income Tax. This case is reported in 127 ITR Tribunal at page number 169 and the date of the judgment is 15th May 2025. The present case relates to the assessment year 12-13 to 15-16. In the present case, the assessment of the assessee was already completed under section 143 subsection 3, and after the assessment, the AO got the information from the investigation wing that the assessee has some tainted transactions. So after getting the approval from the additional commissioner, the notice to the assessee was issued under section 148. When the notice was issued, the assessee raised objections which were disposed of and were rejected, and the assessment was completed by making the two additions, one for making undisclosed income and one for undisclosed investments. The assessee challenged this assessment by raising various grounds, among which two grounds were relating to the mechanical approval under section 151 and the other ground was that the notice has been issued on the basis of borrowed satisfaction by the assessing officer. When the tribunal heard the matter, the tribunal reviewed the approval given by the additional commissioner, and in that approval there was a pre-printed line on which the additional commissioner has put his signature, and that pre-printed line says that yes, I am satisfied and the notice may be issued to the assessee. According to the assessee, there is what shall in section 148 which says that the assessing officer has to issue the notice if the assessing officer finds that some income has escaped assessment. According to the assessee, the word may in the approval letter does not have any authoritative value and it gives the discretion to the assessee that the notice may be issued or may not be issued. The assessee said that may imply discretion and not the satisfaction. When the tribunal heard the matter, the tribunal was of the considered view that in the present case and from the reading of the pre-printed format and pre-printed satisfaction of the additional commissioner, it is very apparent that the approval has been given very casually without application of might. The tribunal said that it was non-authoritative and it was without a proper mandate of direction. The tribunal said that in the present case, the additional commissioner has left decision to the assessing officer whether he may issue the notice or not, so it is not as per the section 151 mandate of the Income Tax Act. The tribunal said that shall does not mean may as per the rule of interpretation, and it is very clear that the approval has been given in undue haste. Friends, this case is very important because this case throws the light that the objective satisfaction of the additional commissioner is very much required, and in the present case, since not a single word has been uttered by the additional commissioner while giving the approval, and it is also a settled law that the approval should be a judicious exercise which is not apparent from the facts of the case and from the record file. So the assessment is liable to be quashed on the ground of mechanical approval. At the end of this video, once again I am repeating the name of the case. The name of the case is Rungta Irrigation Ltd versus Assistant Commissioner of Income Tax, and this case is reported in 127 ITR Tribunal at page number 169, and the date of the judgment is 15th May 2025. Thank you, friends.